Reserves. The gentleman from Ohio is recognized.
Mr. Speaker, I yield 3 minutes to the chairman of the House Oversight Committee, good friend from the great state of Kentucky, Mr. Comer.
The gentleman is recognized for 3 minutes.
Thank you. I appreciate the gentleman from Ohio for yielding. Mr. Speaker, I rise in support of the resolution. This is not a complicated matter. The Oversight and Judiciary Committees issued duly authorized legal subpoenas to Attorney General Garland for a certain set of documents, including the audio recordings of Special Counsel Hur's interview with President Biden. The Attorney General has refused to produce these audio recordings. Unlike what my Democratic colleagues keep claiming, this is not just Republicans who need these recordings for their oversight duties. Media outlets, including the AP, CBS, CNN, NBC, and the Washington Post, among others, have filed suit to get these same audio recordings as well. Because the media, like everyone else, knows there's no substitute for a recording of an interview. Not a transcript, not a summary, not the Attorney General's judgment that Congress doesn't need it. The Oversight Committee's investigation of these classified documents has already revealed that the White House's official timeline of events regarding these classified materials left out very important details. For instance, White House employees were entering the Penn Biden Center and moving documents months before the discovery of the classified materials by President Biden's personal attorneys in November 2022. One of those employees was former White House counsel Dana Remus. We issued a subpoena for Mrs. Remus's deposition, but the White House has blocked Mrs. Remus from speaking to the Oversight Committee. The White House has also blocked other White House employees who visited the Penn Biden Center before November 2022 from speaking to us. What is the Biden administration trying to hide? Attorney General Merrick Garland's refusal to produce this evidence establishes a clear pattern of obstruction by the DOJ to cover up President Biden's wrongdoing. President Biden has lied to the American people about his mishandling of classified documents. He has repeatedly denied not knowing about or being involved in his family's influence peddling schemes, which the Oversight Committee can now show has raked in $18 million from foreign individuals and entities for the Biden family members, including President Biden himself. He also met with nearly all his family's foreign associates. President Biden's Department of Justice appears to be taking every step to insulate him from the consequences, whether it's hiding these audio recordings or attempting to give Hunter Biden a sweetheart plea deal to shield Joe Biden from facing accountability for his role in his family's influence peddling schemes. This is unacceptable. The House of Representatives cannot serve as a necessary check on the presidency if the executive branch is free to ignore the House's subpoenas. I urge my colleagues to hold Attorney General Merrick Garland in contempt of Congress, and I yield back.
Gentleman yields back. Gentleman from Ohio reserves. Members are reminded to refrain from engaging in personalities towards the president. Gentleman from New York is recognized.
Mr. Speaker, I now yield 5 minutes to the distinguished chairman, ranking member of the Oversight and Investigations Committee, the gentleman from Maryland, Mr. Raskin.
Gentleman is recognized for 5 minutes.
Thank you kindly, Mr. Speaker. Our colleagues invite us today to become the first Congress in the history of the United States to hold someone in contempt for complying with our demands. And their target is the Attorney General of the United States. Attorney General Garland gave us the special counsel's report on President Biden in full. He made the special counsel available to us in committee for hours of testimony where he answered all our questions, and he provided the full transcript of the president's voluntary 5-hour interview with the special counsel, all 250 pages of it. The whole world can read President Biden's interview and his answers unedited. But that's apparently not enough. Now they want to hold the Attorney General in contempt for not turning over the audio tape of the interview that we have the verbatim transcript of. And why is that important? Well, in case you've lost the thread of this madcap wild goose chase, America, remember this is an impeachment investigation. Do they think that the holy grail of the 118th Congress, evidence of a presidential high crime and misdemeanor, is lurking in the pauses or the background throat clearings and sneezes on the audio tape? Well, of course not. They know there's no high crime or misdemeanor to be found because they've spent the last 17 months and millions of our taxpayer dollars looking for it, and it simply does not exist. They literally don't even know what they're looking for anymore. So why do they want it? Well, they're hoping that in the 5 hours of President Biden's testimony, they can find a mispronounced word or phrase or a brief stammer, which they can then turn into an embarrassing political TV attack ad. Get it, America? That's what this is all about. And holding the Attorney General of the United States in contempt is one more useful distraction from the complete and devastating implosion of the Biden impeachment probe, which of course was the number one priority of these talented leaders. Remember, they promised to reveal the greatest presidential high crime and misdemeanor in American history, an act of treachery and deceit that dwarfs even the incitement of a violent mob insurrection and an attempted political coup that took place right here against our Constitution, our Congress, our Vice President in this chamber. But after their truly prodigious investigation, punctuated, admittedly, by some unfortunate mishaps like Chinese spies, fake evidence, pornographic displays in committee, and their own witnesses testifying that there were no grounds for presidential impeachment, they have nothing to show for their arduous work other than one more debunked Russian disinformation operation and one more indicted GOP informant and star witness. Rather than admit defeat in this bumbling operation and look for some other way to actually aid the public good, they've decided to flail about in mock outrage against a series of phantom tyrants in the hopes of distracting everyone from this epic flop. Their first distraction was to impeach Secretary Ali Mayorkas as a paltry consolation prize, but that pathetic decoy action blew up in their hands. Then the plan was to skip the mundane work of casting votes and actually doing committee business to travel on a collective spiritual pilgrimage on Amtrak to New York City to attend the criminal trial of an unmentionable American felon, one of 19 million in the country. But that strange journey to Mecca also blew up in their faces when this mystery political false prophet was convicted unanimously by a jury of his peers on dozens of felony criminal counts in a fair American trial. They tried to salvage the credibility of this bizarre expedition by blaming the American justice system for being weaponized against Republicans. But this political extremism quickly melted away when the son of President Biden, the original target of their wrath, was also prosecuted and convicted, like another disarmed felon whose name may now not be spoken on the floor, apparently, by a unanimous jury of his peers on all counts against him. And that trial, unlike the trial whose very existence must be sent down the Orwellian memory hole to save someone hurt feelings, was actually tried in the federal system. So what's left to do now? Well, let's hold the Attorney General of the United States, Merrick Garland, in contempt, of course. This will be sure to placate an unrepentant and anonymous convicted felon from New York and distract everybody else for a day or two. I confess it's a bit rich, Mr. Speaker, to be asked to hold the Attorney General of the United States in contempt of Congress for overwhelmingly complying with the committee's demands by members who voted against contempt citations for Steve Bannon and Peter Navarro, two persons subpoenaed by the January 6th Select Committee who never spent a single minute. Could I have one more?
The gentleman's time has expired.
I grant the gentleman an additional minute.
Bannon and Navarro never spent a minute with the January 6th committee, never turned over a single document to our committee. These people had 0% compliance with Congress. They demonstrated true contempt, which is why they've been sentenced to jail. But Chairman Comer, in his wisdom, would hold the Attorney General of the United States of America in contempt for what I think is 100% compliance, but in any event is something like 98 or 99% compliance. If you think a federal official is not rendered proper compliance, you take them to court, you don't hold them in contempt, and it's rich beyond measure, like a billionaire rich, to be asked to hold the Attorney General in contempt by people who themselves received subpoenas to testify before the January 6th committee, who never rendered a single document nor a single minute of testimony to the January 6th committee. I urge Congress to reject this absurd motion, and I'm happy to yield back to the chairman.
The chair would remind members to refrain from engaging in personalities toward presumptive nominees for the office of president. Recognize the gentleman from Ohio.
Thank you, Mr. Speaker. First of all, I never said I wouldn't testify in front of the January 6th committee. I just want to know what the parameters that testimony were going to be. So I never did say no to that. Second, the speaker before just said we don't know what we're looking for. We're looking for equal treatment under the law. Special Counsel Hur found Joe Biden knowingly kept classified information. Joe Biden knowingly disclosed classified information. He told us that on the very first page of his report, and then he told us later why he did so. He said he had strong motivation for ignoring classified procedures because he was writing a book for which he got paid $8 million. Again, we have motive, and we have him knowingly disclosing classified information. But he doesn't get charged. Yet President Trump does. President Trump does by Jack Smith. Jack Smith, the guy who had to file with the court a notice saying that he actually altered the order of the documents he seized on the raid of the president's home. He had to tell the court that. The physical documents don't match up with the scanned documents. You're not allowed to change the sequence of the documents you seized. But Jack Smith did. Jack Smith mishandled the documents he's accusing President Trump of mishandling. You can't make this stuff up. That's what we're focused on. And, oh, by the way, we're in the midst of an impeachment inquiry. We're entitled to the best evidence. That's why we want the audio tape. With that, I yield 3 minutes to the chairman of the crime subcommittee, the gentleman from Arizona, Mr. Biggs.
Thank you. I thank the gentleman for yielding. During his testimony before the House Judiciary Committee, Special Counsel Hur stated that, quote, the evidence and the president himself put his memory squarely at issue, close quote. In his report, Special Counsel Hur noted that during both his and Zwanitzer's interviews with President Biden, the president's memory was significantly limited. President Biden has contested that. The Democrats contest that. But in reality, it's the failure to fully comply with the committee's subpoenas regarding the audio recordings of the Biden and Zwanitzer interviews that has hindered the House's ability to adequately conduct oversight over Special Counsel Hur regarding his investigative findings and the president's retention and disclosure of classified materials, and has impeded the committee's impeachment inquiry. So, the committee must assess whether the Special Counsel Hur's declination decision, which was based on President Biden's poor mental state, was consistent with the department's commitment to impartial justice, or whether legislative reforms are necessary regarding special counsel investigations because they are not leading to impartial outcomes. In short, the audio recordings would offer unique and important information to advance the committee's impeachment inquiry and inform the Judiciary Committee as to the need for legislative reforms to the operations of the department or the conduct of special counsel investigations. Those are legislative purposes, they are constitutional purposes, and they justify us getting the audio recordings. But they don't want the audio recordings to come forward. Why is that? It's odd, isn't it? Because the DOJ admitted in court filings 2 weeks ago that they actually did alter the transcript. They claim, oh, there's just filler information. Maybe there were duplicative words. There were blank pauses in there that were not noted in the transcript. That's why an audio recording is important, because the transcripts do not reflect important verbal context, such as tone or tenor, or nonverbal context, such as pauses or pace of delivery, all of which went into the decision by Mr. Hur not to prosecute a crime that he said was committed. That prosecutorial discretion is under review by our committee legitimately and constitutionally. We have the right to that audio recording. The department has said they're not going to give it to us. Odd. Because the cases that deal with requiring the audio recording to be turned over, the long skein of cases, they turn on various things like the audio recording is the best evidence. They say that. Odd. They also say that if there's tampering or any kind of editing or altering of the written transcript, which we now know is true, then the audio recording is mandatory. That's why we should get it. This department won't give it to us. Merrick Garland is in contempt of this Congress, and he needs to be held in contempt. And with that, I yield back.